Welcome back. This is Tony Barillary with Barillary and Williams LLP. Today I'm going to talk to you just a little bit about some estate planning devices. The most common of which is your Revocable Trust. Most people have heard of this as a probate avoidance device. It does help you to avoid probate. It can also help your estate to get administered rather quickly after you pass, rather than going through this really long process that has to happen if you die in the absence of a trust and leave property behind. So that's the number one that you can use. Number two is going to be called a will, or if in the case where you have a trust in place, a pour over will. What that will does is it pours over into your trust any assets that weren't already held by you in your name as the trustee of your trust. And it can serve as evidence that your property was intended to be rather trust property, which means that it can get confirmed into your trust in a rather quick procedure by the court, as opposed to needing to go through the probate process, which is really expensive and time consuming. Third document is called a durable power of attorney. They are called durable because the person who you name to represent you, to act on your behalf, can still do that even when you lose capacity if the power of attorney is durable. These are often made springing, which means they're only effective when you lose capacity. So you can put this document in place and no one can use it to go and legally sign on your behalf and bind you to things unless and until you reach a situation where you just simply can't handle things anymore. Maybe you're laid up in the hospital and in a coma or something, and somebody needs to step in and handle your finances so that your loans don't default and so that they can pay for your care and that sort of thing. So that's your durable power of attorney. It's very much a during life document. And then the last and very important document is called your Advanced Healthcare Directive. This is sometimes referred to as a living will. And what it does is, first, it specifies a person who can make medical choices for you in the case that you're not able to do so yourself. So let's say you're laid up in the hospital, you're unconscious, and a decision needs to be made whether to do a procedure or not do the procedure. The person that you name under your Advanced Healthcare Directive will have the legal authority to do so. Another thing that the Advanced Healthcare Directive does is it names, for the person that you name, it allows them to get a hold of your medical records under the HIPAA laws and the CMIA laws. CMIA, CMIA, is California's Medical Privacy Act, in the same way that HIPAA is the federal Medical Privacy Act. So without some kind of authorization there, medical providers are not legally allowed to disclose your medical information except to certain individuals under certain circumstances. Very importantly, your Advanced Healthcare Directive, the living will aspect of it, it tells your loved ones what you want to happen with you if you're in an irreversible coma or a persistent vegetative state, or in some other way unable to communicate and basically brain dead, where you're not ever going to recover. Now, some folks want to be kept alive under any circumstances, and your Advanced Healthcare Directive is a place to specify that. And other people don't want to be kept alive under those circumstances. If they feel like, I'm not going to recover, I don't want my resources wasted from my estate just to string me along, only to pass away later without ever waking up again. So whatever your feelings on that are, it's really good to set those forth in a document that hospitals and doctors can rely on. It helps to ensure that your wishes get fulfilled, and it helps to foreclose the legal arguments and the arguments amongst the family members, which are very emotional and very heated when the time comes when nobody knows what you really wanted, and then people are left to try and figure it out on their own. So those are the basic 4 devices. Obviously, there are many, many estate planning devices out there in addition to these. I would say that 99.9% of estates are going to have these 4 documents as a part of that plan, but they won't be the exclusive documents there. This is just some basics for you. If you have any questions, feel free to throw us a comment in the comment section or reach out to us. We'd love to hear from you. And that's it for today's video. Hope to see you again soon.